Thanks, Doc. We are ready to start now.
Okay, thanks, Kamo. Good evening, colleagues, and welcome once more to our weekly webinars. And just a day after we celebrated Women's Day, and we trust that everyone was able to take time to relax at home, and those who were able to join the celebrations. We hope that everything went well during those celebrations. And thanks that you are all here again in the middle of the week. The celebration were, but nobody went away, or at least those who could have gone away, they're still with us at this webinar. These are CPD accredited webinars organized by Phoenix Health Group. And we've been doing this for the last 2 years or so, 2.5 years since the lockdown 2020. And we are grateful and appreciative of the fact that you've been staying with us. And there are many more new people joining us every week to participate in webinars where we invite experts in their different fields, both medical and other allied health professionals and nursing. And also we hope to be getting those from the pharmacy discipline sometime next month when we celebrate Pharmacy Month. And so this evening, the CPD meetings is also streamed live on YouTube. And we note that when you register, you give us your full details, name, surname, and email address, so that we can send you weekly invitations, and also your registration number, either with the HPCSA or Nursing Council, so that this can be sent to the relevant authorities and you can get your CPD points. And this evening, we're excited to have Dr. Shakeera Holland, who is the head of clinical unit at Diepkloof and Sebokeng Cluster for Forensic Pathology Services in the Gauteng Department of Health. She is also the academic head of the Department of Forensic Medicine and Pathology at the University of the Witwatersrand. And her duties involve conducting the medico-legal investigations of unnatural deaths, attendance of scenes of death, performance of medico-legal post-mortem examinations, including special investigations like histological analysis and interpretation of toxicological analysis results approximately. That's a lot, 6,000 post-mortems in unnatural deaths performed to date, and also compiling of medico-legal post-mortem reports, appearing in court as an expert witness in the Johannesburg and Greater Gauteng magistrate courts and the High Court, and also inquest courts, and review and providing medical opinion in inquest dockets. We also contact quite a lot when we need some opinion on cases that we encounter within our groups, and also when I was in Gauteng. She's got a MSHB and a fellowship in pathology, and an MMed, forensic pathology, and also a MET and a diploma from the College of South Africa. And so she'll be talking to us about the medical legal management of natural hospital deaths. Quite an involved topic, considering where we are working at the moment. So Dr. Holland, quite a pleasure to welcome you and to give us a talk, and we're looking forward to new information and guidelines on how to manage these unnatural deaths in our settings. Welcome to these webinars. Thank you very much.
Thank you so much for that very warm welcome.
Sure.
Let's see. Okay, so I'm just trying to start my presentation. It was working just a while ago.
Oh, so sorry, Doc. You can click anywhere on your slide and then just try navigating.
Okay, let's see. Aha. So, where did it all start? In ancient Rome, the first recorded autopsy was by Antistius, a Roman physician who performed the autopsy on the murdered body of Julius Caesar, who was murdered by his senators in 44 BC. Of the 23 knife wounds on the body of Caesar, only one wound was fatal, and that was the cause of death. A fatal knife stroke made between the first and second rib with an upward angled thrust just under the left shoulder blade, which pierced his heart. He was literally stabbed in the back. And it was the origin of forensic medicine when in ancient Rome, friends of the court provided expert testimony and advice to judges on complicated matters. So the talk would be an introduction to the forensic pathology service, the definition and legal framework of unnatural deaths, and the relevant forms and processes in hospital unnatural deaths. Medico-legal death investigative services are different in different parts of the world. You would have heard the term coroner and medical examiner systems. So the coroner system is where an elected official is appointed to oversee the medico-legal death investigation in a country. Now, this particular person doesn't have to be medically trained and essentially could be anyone. Nowadays, there are still countries that have the coroner system, although we know that most coroners do have some sort of medico-legal background. So the medical examiner system was started in the United States, where medical doctors who specialize in forensic pathology actually ran the medico-legal death investigation system, which makes a lot more sense. In South Africa, we have the forensic pathology services, and forensic pathology services are the custodians of all unnatural deaths in the country. Our business includes the equitable medico-legal investigation of death, establishing causes and circumstances of unnatural death, and gathering evidence to facilitate the criminal justice process. And we hope that through excellence in the above, we want to assist in the prevention of unnatural deaths and assist in the fight against crime. So in the Johannesburg area, so Gauteng is divided up into the northern and the southern clusters, and Johannesburg falls under the southern cluster. The forensic pathology services have 8 medico-legal facilities in the southern cluster. In our 8 facilities, we do approximately 15,500 unnatural cases per annum. In the northern cluster, they do approximately 3,500 cases. So in the whole of Gauteng, we're sitting at around 18,000 to 19,000 unnatural deaths per annum. So that's just in Gauteng. That's just to give you an idea of the extent of the problem that we face in this country when it comes to unnatural deaths. So there are 4 big categories of unnatural death as contemplated in the Inquest Act, as well as defined in the National Health Act, in the regulations regarding the rendering of forensic pathology services. So the first big category, which I'm sure you're all familiar with, is death where there's application of force. Now, this may be biological, physical, or chemical force. It encompasses mechanical injuries like your stabbing, shooting, and blunt force injuries that you could get in a motor vehicle crash, for example, thermal and electrical injuries. So something like lightning, although a natural phenomenon, is also considered unnatural if it causes the death of somebody. Chemical or drug-related injuries like an overdose, for example, and even biological forces like dog or snake bites. The second big category would be an act of omission or commission by medical staff. So this is where somebody is admitted to a medical facility because of a natural cause, and something has happened in that admission. So either the medical practitioner has acted in a way that has led to the death of the patient, or has not acted and that has caused the death of a patient. So those categories would be the act of commission or omission. The third category would be the sudden, unexpected, or unexplained deaths. So this is where somebody without a medical history just dies suddenly. That death is unnatural until proven otherwise. And the fourth category are procedure-related deaths. So as clinical practitioners, you are going to see all 4 categories in your practice. There are 3 important acts which govern the procedures that need to be followed when a patient or person dies. They are the Birth and Death Registration Act, the Inquest Act, and the Health Profession Amendment Act. The Birth and Death Registration Act basically states that when a death is unnatural or other than natural, that death must be reported to the police. And once a death is reported to the police as an unnatural death, there must be a medico-legal post-mortem examination and an inquest. And this does not require consent from the families. It is a legal, mandatory obligation. The Birth and Death Registration Act also states that failure to inform the state of an unnatural death or giving false information of any birth or death, counterfeiting of any document related to a birth or death, and unreasonably withholding certificates or documentation related to a birth or death is against the law. The Inquest Act provides the holding of inquests into unnatural deaths. It also makes it mandatory for the reporting of other than natural deaths, as does the Birth and Deaths Registration Act. It states that there must be an investigation into the circumstances of unnatural deaths, documents the procedures that need to be followed at the inquest, states which findings need to be made at an inquest, and then contemplates the legal processes that follow an inquest. When it comes to the reporting of other than natural death, it is very clearly stated that if any person knows that a death is unnatural, that person has an obligation to report the death. So whether you are a medical practitioner or just a lay person, you actually have the legal obligation to report that death. And failing to report this death would constitute an offense. So technically speaking, if you are aware of an unnatural death and you haven't reported it, whether you are a lay person again or a medical practitioner, you do not report a death, you can be held legally liable. The Health Professions Act has changed. So the old Act before 2008 stated that when a person died under the influence of anesthetic, whether it was local or regional, and where the anesthetic has been a contributory cause to the death, that death would be considered unnatural. Now, a lot of people still think that a death under anesthetic is unnatural. So what happened was that the law changed, and after 2008, it has now become a procedure-related death. So instead of an anesthetic, it's now become a procedure-related death, where a procedure is considered a surgical procedure. And it now states that when a person undergoes a procedure and dies during the procedure, or where the procedure has contributed to death, that death will be declared unnatural. Again, this means that in those cases, no consent from the family is necessary to perform the medico-legal examination, which would include an autopsy. So what do you do when a patient has died? So firstly, the death must be certified, and according to the law, death is brain death. The medical practitioner must then decide, is the death natural or other than natural or unnatural? Then the medical practitioner must decide whether or not to issue a notification of death form, which is called the DHA 1663, and this is in accordance with all the laws we've just mentioned. If the death was solely and exclusively as a result of natural disease or a natural disease process, the medical practitioner may issue the notification of death form, and this must indicate a cause of death on the form. However, if the death is unnatural, the medical practitioner should not complete the notification of death form, and the deceased body must be referred for medico-legal post-mortem examination, which obviously requires no consent from the families. So you're all familiar with this. This is the DHA 1663, which is the death notification form, and the areas that are ringed indicates who has filled in the form. And then on the last page, you have 4 spaces where it talks about the cause of death. And that's just to show you that you can either tick the natural or the unnatural, depending on the nature of the death. Once you've ticked unnatural, that the medical practitioner is not in a position to say that the death was natural, that is the end of the form. You are not required to fill in anything further. The case must then be reported to the police, and the medico-legal autopsy must take place. Once the forensic medical practitioner has performed the medico-legal investigation of death, which includes the autopsy, that practitioner will issue the finalized DHA 1663, and on that DHA 1663, the cause of death will be indicated. Then the last page of the DHA 1663, this is in fact a confidential page. So all the information that is filled in on this page relating to the cause of death is confidential. That last page should ideally be sealed and sent back to Home Affairs, where it is used for statistical purposes only. And I think it's very important now to just review the different definitions of how we classify the terminology when we're filling in that last paragraph of the DHA 1663. So the cause of death. So the legal definition of the cause of death is the disease or injury which initiated the train of morbid events resulting in death. So an example would be something like a meningococcal meningitis in the case of a natural death, or something like blunt force head injuries if it is unnatural death. Now, often what happens is that medical practitioners confuse mechanism of death with cause of death. So you'll often see sort of cause of death written as a cardiorespiratory arrest, when in fact that is not a cause of death, but in fact a mechanism of death. So the mechanism of death is the pathophysiological derangement resulting from or following the primary cause of death. So if we use the examples as stated above, something like cerebral edema with raised intracranial pressure and status epilepticus would be the mechanism of death in a case of blunt force head injury or a meningococcal meningitis, for example. We then also refer to the manner of death, and this is the circumstances under which the death occurs. So it can be natural, can be accidental, suicidal, homicidal, or undetermined. So there are some cases where you cannot classify the death in any of those four categories. And a homicidal death just implies that somebody is responsible for the death of another person. So it does not always necessarily mean the intention of murder. So for example, if we look at how the final formulation of the cause of death would be done and how the DHA 1663 should be filled in, you would write first on the first line status epilepticus due to raised intracranial pressure, due to blunt force head injury or meningococcal meningitis. And in that way, you've covered the primary cause of death as well as the mechanism and manner of death. There's also a section that talks about contributory causes. So this is basically something in the deceased that contributes to a faster death, or somehow shows that the deceased was not able to cope with certain conditions, as well as somebody who is in good health. So this example just shows that something like malnutrition would be a contributory cause in somebody who dies with a bronchopneumonia due to measles, for example. So what about the hospital cases? So when you have a death in hospital and that death falls under one of those four major categories of unnatural death, what do you do? So every single hospital death, you must have something called a D28. So the D28 is the name of the form we use in Gauteng, and it is basically a clinical summary of the hospital admission of the deceased. When there was a surgical procedure involved, then a GW724 is also required. So this GW724 is a record of the procedure as well as of the anesthetic. Obviously if there was no procedure, D28 only, but if there was a procedure, GW724. So the other important form that clinicians or medical practitioners are not often aware of is the SAP 180 form, which is what it's called in the whole of South Africa. So the SAP 180 form is filled in by the police, and it is basically a declaration that a death is unnatural. Only once the police have filled in the SAP 180 form can the forensic pathology services take custody of the body of the deceased. Generally, the practical aspect of how that happens in hospital is that the clinicians or the medical practitioners fill in the D28 or the GW724, and then the people dealing with the actual, the processes of what happens to the body of the deceased, they make sure that the SAP 180 is filled in by the police. But without a SAP 180, the forensic pathology services can't do the medico-legal investigation of death. Generally, this is the information that is on the D28 and the GW724. We're looking at the demographics or the information about the patient, the information about the treating doctors and the medical staff involved in the treatment, the time and date of the admission, the time and date of the death, all the injuries of the deceased if there were injuries, and preferably on a schematic or a diagram, the surgical procedures and the details thereof, the anesthetic record, any evidence that was collected, which includes forensic evidence, any complications that arose during the hospital stay, all the events leading up to death, and finally the opinion as to the cause of death. So this is just an example of what a D28 looks like, and this particular one was from the Old Johannesburg Hospital. All information is technically what should be on any D28. Certain hospitals or facilities adapt the D28 with their logo or heading, which is also completely fine, as long as this information is there. You will see that you start off with all the patient details. There is a diagram for any wounds or injuries can be noted on the diagram. There is a place for whether or not there was any forensic evidence retained. We can see that it's very important that this is an affidavit, so this is a legal document. Therefore, the details of the person filling in the document is very important, and this document needs to actually be affidavitted by a commissioner of oaths, which is usually somebody has one in every hospital. So this is a legal document. The GW724 is the surgical or anesthetic record. In Part A, you have a place for information about the patient, so all the demographic details, as well as the medical staff looking after the patient. In Part B, you have everything to do with the treatment or the pre-operative condition. In Part C, there are particulars of the procedure that is undertaken. Part D is the anesthetic record. And in Part E, there is anything else that needs to be included. So anything about the circumstances of death or anything else that is relevant to the anesthetic or procedure. So here's where the challenge comes in. So you have these documents, and often what happens is that the documents are not filled in adequately. So when we are doing the medico-legal post-mortem examination, the more information we have, the more we can provide. And often we know that patients are in hospital for quite a long time. They undergo a number of procedures and a number of things happen to them. And therefore, we may only see patients may only die sort of months after the initial hospital admission. So if these forms are not adequately filled in, it becomes really difficult to tease out the details of the case when you are doing the post-mortem examination. So the major challenges we have, number one, illegible notes. Now, I know my handwriting is really not great, but we must be able to read what you're writing. We must be able to see who is the doctor filling in the form, and we must be able to see contact details of the medical practitioner. Often we do have cases where we need information, so perhaps we need to get a bit more information about something that's written on the notes, or we may need something else that will help us with the post-mortem examination. So it's very helpful to be able to see who the doctor is that filled in the forms and how to get hold of them so that it stops us from ending up with a lack of information once the case goes to court. We want to know the results of relevant tests or investigations that have been done in hospital. Often, we'll get a D28 where the clinician will write CT scan performed, for example, but no information about the CT scan. So, CT scan of what? What did it find? How was it related to what happened to the patient in hospital? Something like blood results. So the clinicians may write toxicology performed, but then no idea of what exactly was done in the toxicological screen, what were the results. And even when it comes to blood results, they can be relevant, especially if any of those blood results help us understand the cause of death in that deceased patient. There's also often a lack of clarity on forensic evidence. So often, in cases of gunshots, the medical doctor or practitioner would write bullet identified, right? No information about where was that bullet seen? Was it actually removed? If it was removed, what happened to it? Was it given to the police? Was it put into a relevant seal number? How are we going to trace that bullet when it comes to the actual court case related to the deceased? Something like clothing, which is very important in a sexual assault. So if you have a patient who comes in with a sexual assault and other injuries, and the clothing is taken, that clothing presents vital evidence, whether or not the patient does eventually live or dies. Because without that clothing, you have a big missing link as to trying to link the perpetrator with a crime. So I think often, because I suppose it's not something that medical practitioners deal with in a clinical sense, forensic evidence is often not thought of and often forgotten in the process of trying to treat someone and save their lives. What is the medication that the patient is on? Now, this can be very relevant because we know that sometimes, medication can be involved in the death of a patient. So we need to know the relevant medication as well as the dosages if it is relevant. And then often we don't see, there's not clarity on the reason for the medico-legal post-mortem examination. So in the beginning, I shared with you the 4 big categories of unnatural deaths. And we sometimes get cases from hospital where obviously the medical practitioner thinks that the death is unnatural, but that the reason is not reflected within the D28 or GW724. So remember, the only thing that forensic medical practitioners have when a body is admitted to the mortuary is the documentation that is provided by the clinicians. So without complete information, it makes our job very difficult. And then the other thing I've often encountered is that when people phone me about the D28 or information that is needed, they say to me, but there's no space, so, there's only a limited space on the form. But that doesn't stop you from adding extra pages or adding sort of a result. So in the case of a CT scan, you may want to add a copy of the CT scan results, as long as it's noted that a CT scan result has been added and it's been signed as part of your affidavit. Please add more pages. Send us any other investigations you think are relevant. If you have a typed clinical summary and you'd like to include that, please do send that, right? And also know that the information that you share can be used in court. So obviously, we would never advise that medical practitioners incriminate themselves when they submit these documents. So we want you to be honest about the treatment of the patient, but not sort of have a declaration of a confession, for example, saying like, I was responsible for the death of a patient, or so on and so on. We just want the facts as to what exactly happened to that patient. So what about the category of sudden, unexpected, or unexplained deaths? These deaths often come to hospital as the so-called DOAs. Right. Now, the Birth and Death Registration Act says that where a medical practitioner is satisfied that the death of any person who was attended to before his death was due to natural causes, a death certificate shall be issued. So in other words, if a patient is known to a clinic, for example, so it's somebody who has a history of a chronic autoimmune disease, and that patient is known to the hospital and comes in and suddenly dies, right? That death is not exactly a sudden, unexpected death. So the key word here is the word unexpected. So a sudden death doesn't equal a sudden, unexpected death. A sudden, unexpected death would be a death where there is no history. So if the medical practitioner is the same person who's the treating physician and knows the history of the deceased and examines the body before to see that there's no evidence of trauma or has any reason to suspect foul play, that medical practitioner can sign the death as natural. What about the case where the patient is not your patient? So there is a DOA, the patient may be known to the clinic, but you are not the direct treating physician or treating medical practitioner of that patient. Well, the Birth and Death Registration Act says that you can still sign that case out as natural if you have a relevant history and you've examined the body of the deceased to make sure that there was no evidence of foul play or anything unnatural. So it gives medical practitioners the right to sign out cases as natural, whether they were treating the deceased or not the primary medical practitioner treating the deceased, if there's a history and if the medical practitioner has examined the corpse to make sure that there's no evidence of an unnatural disease. I also must mention, what about the case of a stillbirth? You may see a stillbirth in your practice. So sometimes, a pregnant woman can come in and give birth sort of unexpectedly, or it may be somebody that's not booked, and you may end up with a stillbirth as a so-called DOA. What does the law say? So the Birth and Death Registration Act basically says that in order for the law to recognize that a fetus is a child, that fetus must have undergone 26 weeks of intrauterine life. So in other words, any fetus that is less than 26 weeks is not considered a person in the eyes of the law, and therefore does not require a DHA 1663. I think that's often a very difficult thing for people to understand, because it doesn't feel ethically good or correct to not sign out a fetus of less than 26 weeks. But in the eyes of the law, it is not necessary to issue a DHA 1663 in a stillborn or a stillborn fetus of less than 26 weeks. So what does it say? The Birth and Death Registration Act states that a medical practitioner who was present at the stillbirth or examined the body of the child and is satisfied that the child was stillborn can sign that child out as a stillborn. If no medical practitioner was present at the stillborn, or the body of the stillborn was not examined by a medical practitioner, if there is a history that somebody who has witnessed the birth can make to an authorized person and state in an affidavit about what happened, that death can still be signed out as a stillbirth. A question about notifiable diseases. So notifiable diseases are not medico-legal per se. We often get the impression that clinicians think that maternal deaths, for example, are automatically medico-legal, and that is not the case. A maternal death is only medico-legal if it forms part of one of those 4 big categories that we spoke about in the beginning: death due to force, omission or commission, a sudden, unexpected or unexplained death, or a procedure-related death. So all maternal deaths are notifiable, but not necessarily medico-legal, and all notifiable deaths are not medico-legal per se. Okay, so those notifiable deaths would have to fall under those big 4 categories for them to be medico-legal. So this is just a summary of everything that we've spoken about. So we have the 2 big categories: death due to unnatural causes, death due to natural causes. And you can see that the circumstances of the death in unnatural causes would be accidental, suicidal, homicidal, or sudden, unexplained or unexpected deaths, as well as the procedure-related deaths. The laws governing those deaths, again, are the Inquest Act, the regulations regarding the rendering of the forensic pathology service in the National Health Act, the Health Professions Amendment Act, and the Birth and Death Registration Act. If a death is unnatural, do not complete the DHA 1663. An SAP 180 must be filled in for the police to declare that a death is unnatural. The body of the deceased will then be taken by the forensic pathology services. If it is a hospital death, all hospital deaths need a D28, which is a clinical history. If that death is related to procedure, a GW 724 must be completed. The deceased is then admitted to the forensic pathology services, where medico-legal autopsy is performed and a report is then issued based on the findings. That medico-legal report will then go to the South African Police Service, who will investigate the case, and then that case with the investigation, including the medico-legal report by the forensic medical practitioner, as well as the investigation by the police, will go to court, either the inquest court or the criminal court, depending on the facts of the case. And of course, if a death is natural, the medical practitioner can complete the DHA 1663, the death can be registered, and then the family can take the body of the deceased to bury or dispose of as per cultural or religious beliefs. And so just to give you an idea, so what happens then? So now everything is completed. What about these unnatural deaths that the forensic pathology services have now completed? So the Inquest Act gives us a summary of what happens in these cases. It talks about the reporting of other than natural deaths, the fact that all deaths must be reported to the SAPS. If they are unnatural, there must be a medico-legal death investigation, which includes an autopsy, and no consent is necessary. A PM report must be issued. All the information from the PM report and the relevant medico-legal investigations that were done as part of the post-mortem examination must be sent to the police for investigation. The police then need to compile everything and submit that information to court. And the magistrate, who is the person who runs the inquest, can either do a paper inquest where they look at all the information that is provided and make a ruling, or they may have a hearing, which is called an open inquest, where they may need different experts to give testimony on the incident and the findings. And finally, the inquest magistrate then comes up with 4 big things. Firstly, the identity of the deceased must be confirmed by the inquest magistrate. The cause or likely cause of death, and this is obviously based on the investigations, of which the post-mortem examination is probably the most useful. The date of death, and whether or not somebody was responsible for that death. And finally, the findings of the inquest magistrate will then be submitted to the Director of Public Prosecutions if the inquest magistrate has found that there's somebody responsible for the death where that person needs to be prosecuted. Generally speaking, most hospital cases, unless it's a shooting or a motor vehicle crash, but the cases of omission or commission or procedure-related deaths generally go through the inquest process. It doesn't mean that every single hospital case will end up in that way, but generally speaking, this route is a hospital death that is not related to force would generally go through the inquest process. So in essence, what is the purpose of all these forms and all these procedures? It is really to protect the public and to protect the medical practitioner and to make sure that every single unnatural death is facilitated in the correct way. Thank you very much.
Thank you very much, Dr. Holland. The dead cannot cry out for justice. It is the duty of the living to do so for them. Beautiful quote that you end up with, but each other is quite macabre. Thank you very much, colleagues. So my video is not on. We've got a few questions for you, Dr. Holland. I don't know if you're closing the presentation. Yeah, there's one. One of the first questions is, where can I get the DHA 1663 form? You're muted. You're still muted.
So
still
the DHA, can you hear me? Sorry.
Sure.
Okay, so the DHA 1663 booklets are actually from Home Affairs. So every clinical practice gets a booklets from Home Affairs, and it's very important because those DHA 1663s have serial numbers on the top. The serial number is linked to you as the facility or the practitioner, because obviously if you have a DHA 1663 that is used for illegal purposes, it can lead to corruption. Because we've had cases where people try and fake their own deaths for insurance purposes, and they have these DHA 1663. So it's got to be a process. It goes through Home Affairs, and it's traceable to the medical practitioner or the facility that signs for those books.
Yeah, so that the books must not get into the hands of wrong people.
Yes, exactly.
This is it. There's a long one here. If I saw a patient a week ago for a minor illness like a flu, and the patient dies a week later, if I cannot say 100% that the cause is related to the flu, can I refuse to fill the DHA 673? Also, if I know the patient that the patient had a chronic disease and the patient decides without me seeing the patient, can I assume that the case was related to his chronic condition, or must I then ask for a postmortem?
Okay, so that would be the two aspects that we discussed in the Birth and Death Registration Act. So I mean, people don't generally die of a flu. I mean, if you're a person without any underlying comorbidities and you get the flu, you shouldn't be dying of the flu. So in that particular case, I mean, you know, it doesn't make sense. On the other hand, if it's somebody who's got chronic, you know, cardiac failure and they've got other comorbidities and they do get the flu, we know that in those cases, influenza can be fatal. So it really depends on the clinical situation of the patient. But essentially, remember that, but the Birth and Death Registration Act says that you can be the person who knows the patient, in other words, a treating physician, or you can be a physician that hasn't treated the patient and you have a history, but you have to view the body of the deceased to be able to sign it out as natural. So that's where you have that almost that leeway to say, look, I've got a history. Okay, we know that, for example, our family, I'm the GP, I'm treating this particular family all the years. The aunt comes to visit from Cape Town and she's now in Joburg. We know that the aunt has got cancer. She just came to say goodbye to everyone. And basically she doesn't wake up one day. So although I'm not the regular treating physician, I go to the house, I examine the aunt, I know she's got the history of terminal cancer. I don't see any evidence to make it look like this is a suspicious death. The law says that I can sign that case out as natural with the history and the fact that I've viewed the body of the deceased. So I hope I'm answering that question. So obviously, each case needs to be considered in its own unique individual circumstances. But essentially, a medical history, you have to use your clinical acumen, a medical history that is consistent with a fatal condition, as well as the fact that you viewed the body to see that there was no evidence of foul play, means that you can sign the case out as natural. If at any stage you are concerned about it, then obviously you can refuse to sign that DHA 1663. It is your legal right to say that I am not in a position to say that a death was natural, and by so doing, you are saying that that death needs to be investigated.
Okay. The next question is related to that. Says, should I fill up the BI form if a patient died at home and the body was examined by the ambulance team or the emergency services team? And if I could extend the same question, which I think most of the GPs would attest to that sometimes the patient dies at home and then they picked up by the undertaker, they go to the mortuary, and then there's a doctor who does not know the patient, but they end up signing the forms. Is that allowed?
So you see, it is. So I know a lot of the private undertakers do have doctors that do that. As long as that doctor has got a history and has examined the body of the deceased. So again, it's the same thing that we've just discussed, that even if you are not the treating physician, in other words, a regular doctor, but you have a history that explains why the person died and you've examined the body and there's no evidence of foul play, then you can actually sign them out.
Okay. But they have to examine the body.
That's it. That's the whole thing. Because often what happens is that the doctors that are employed by the undertakers to do those forms don't examine the bodies of the deceased and then end up with a problem later on.
Yeah. Philip's name wants to know where are the stats notified or published?
Which stats? The unnatural death stats.
Yeah, well, I take it both, yeah, natural death.
So unfortunately, this is a big problem. So we don't have, in the whole of Gauteng, we don't have a digital medico-legal death information system. We don't have a digital system. All the cases that come in are written in books, still manually. And there's no record of all the deaths that we have. So you do have the stats that come from the police. So those are the national crime statistics. But unfortunately, there are huge chunks of unnatural deaths that are not included in those crime statistics. So at the moment, there's no true accurate reflection of the unnatural death statistics in this country.
Yeah, that's a big problem. Yeah, because if we can just digitize, yeah. Well, I was talking to someone who comes from the UK, and they are saying that in the UK, because correct me if I'm mistaken, in South Africa, the death certificate either says natural or unnatural.
Correct. Or under investigation.
Yeah, but on the investigation.
Yeah.
But in other countries, they actually write the cause of death on the death certificate.
Oh, okay. Look, I don't know. I mean, I've never seen any other countries' death certificates, but in our country, so remember that last page of the DHA 1663 where you've written the cause of death, that is sealed for statistical purposes only. So when you get the final the final death certificate from Home Affairs, it just states natural, unnatural, or under investigation.
Okay, yeah. Which makes it difficult to know exactly the statistics on cause of death.
Exactly. Exactly.
Yeah. Can you please clarify as to where does one draw the line in case of someone who dies years after the incident? But there's a question as to whether that particular incident has now contributed as the cause of death. Yeah, natural or unnatural.
So again, it's difficult to give exact guidelines, but each case must be considered on its merit. So let's take an example of somebody who maybe goes in for a laparoscopic liver procedure, right? So they're fine, they go home, but they've always been, the wife says, he's just always been a bit yellow, since the procedure, but he's otherwise fine. And then dies maybe like a year later with signs of liver failure. Okay, now you're thinking, could something have happened during the procedure? Because we know it was a procedure on the liver, and maybe it was an unrecognized complication. There may be enough clinical evidence to link the death. Okay, but you must link it with clinical evidence. It can't sort of be a completely unrelated event. So if you are finding evidence to say that the procedure, regardless of how long ago that procedure was, is somehow linked to a death, then you may have to call that death unnatural. We had a case recently that was so complicated, and I'll share it with you because it speaks a lot to this whole thing about trying to tease out the details. So a person was stabbed in the 80s, right? Stabbed, but unfortunately never quite recovered and had sort of hernias, periodic hernias that occurred over the years. Eventually died of a strangulated hernia from the original stab wound, right? So now, although it's 30 years later, the reason why they died was linked to that original stab wound that happened 30 years before, because it was never healed. So that he kept on coming back with a hernia, having a procedure, going out, coming back, and eventually that's what killed him. So, I mean, technically that is an unnatural death. So it's not something that I can say this is definite or that is definite. It's actually something that you've got to use your clinical acumen to try and tease out the facts of the case and decide, is it a link or is it not? Yeah. But the fortunate thing is that forensic pathologists can often help you. So we are a service, we provide a service. There's always somebody available. If you have a case and you're not too sure, give us a call, speak to the forensic medical practitioner on duty and find out what, is there a basis for whether or not this case is unnatural.
Yeah, I think I found that quite useful in many cases where we have to assist the practicing doctors to determine whether to do forensic or the next question, that is a medical postmortem. Is there something called a medical postmortem?
There is. So when you know that somebody has got a medical illness and they're dying of a medical illness, but you don't know exactly what happened or you want a bit more detail about it, you can ask for a medical or hospital postmortem. But this, because it's not medico-legal, you would need consent of the family. That is something that needs consent. In the southern Gauteng, I know that the NHLS does these kinds of cases. In the public hospitals, it's a provision that the public hospitals actually pay for. But again, it's saying, look, we know why the person died. It was a medical condition, but we can't quite figure out, a few details as to why this happened in this way. You would need consent from the family to do that postmortem examination, but it can be done.
If the family are the ones who initiate the postmortem request in the private sector, I just want to check. And I'm not certain if you're quite familiar with who would be the payer for because it's a service, in the private sector.
Unfortunately, I don't know. I don't know. But yeah, we do have families that want to have postmortems because, they know that, their loved ones were ill, but they want to know exactly what happened. And they can do it. But and in fact, the NHLS does do cases for private hospitals as well. But in terms of what it costs, I really don't know. I can't say. I don't do private work.
So the NHLS can do it when you don't know if it's at the cost or it's for the private sector, if they're doing it at the cost or not.
They do it at a cost. So in the private sector, the hospital, or I'm sorry, the patient would have to pay for it, is what I understand.
Okay.
So the payment comes from the patient themselves. Okay. Yeah.
Okay. Yeah, there's this question if Vuzani wants to know, even in total, thanks for the talk, how many postmortems should I perform per day in a forensic lab? Wow. This person is a registrar or what? Or is medical officer working in one of the postmortems?
I don't know, I'm wondering. So essentially, what we say is that in order to ensure that we are providing a service and keeping up with our service delivery obligations, but at the same time making sure that the medico-legal postmortem examination is done correctly, we advocate for 4 cases per doctor per day.
Okay. I hope you've not answered. Okay. Now, I hope you've not given ammunition to someone who's trying to get some support to reduction of workload.
If anybody asks me, so we've got as you noticed, I've mentioned the Code of Guidelines and the regulations governing forensic pathology services is in the National Health Act. So if you want to know what legally should be, what should actually be going on, you read the code and the guidelines. It will tell you exactly how things should be done properly in the forensic pathology service, and so it's legal. But essentially, our guidelines are that. Does it mean that there's going to be a day when you don't do 6 cases? No, it doesn't. But as a standard practice, you should be doing 4 cases per doctor per day. If you look at what they recommend in the UK and the US, they are saying that doctors shouldn't be doing more than 250 cases per year. And this is because of the fact that the case is not just about the postmortem examination. The postmortem examination is one aspect, but from that postmortem examination, there's got to be a report. You've got to go to court. You've got to give evidence. So they are recommending that. However, in South Africa, the average, I would say that in South Gauteng, you saw our stats. South Gauteng, I think we are the busiest in the country, doing approximately 17,000 to 18,000 cases in the Gauteng per year. Our doctors are doing 500, 600 medico-legal postmortem examinations per year.
That's a lot.
You see, so we are severely under-resourced. So like I said, there's the ideal and what we would like you to stick to, but it doesn't mean that in times of crisis, you may need to do more, depending. But obviously, you don't want to compromise the quality of the service that you're delivering. So it's got to be a balance between the two.
Yeah. I was listening to someone being interviewed, I think one of the hospital managers recently, about the problems with
the Joburg crisis.
With the crisis and also the storage of the bodies. And
Such a problem.
Yeah.
But the sad thing is that is just one of the 8 facilities. That's just one. Okay. Yeah. So at the moment, Joburg is in the news, but that's just one. We've got 8, and each of those facilities have got similar problems. So understaffed, extremely busy, under-resourced. So it's difficult. It's difficult at the moment.
Yeah. I think that's the issue with the state of public health services at the moment.
Indeed.
That so many people needing access to healthcare, even in death, but the resources are quite few.
Exactly.
Yeah. Bongani Kulu wants to know, a patient is operated for a ruptured appendix and generalized peritonitis, and then has a stormy post-operative period and eventually dies of multi-organ failure a month later. Is this a procedure-related death?
So it becomes very difficult. So if the operation or the deceased has never recovered from the procedure, so peritonitis, then has a relook, then has a sepsis and another relook, and then has a fistula, as often happens, and then develops multi-organ sepsis, then obviously it's linked to the procedure. So it really depends on whether or not the outcomes are linked to the procedure. Having said that, you can get people who've had a procedure, but then incidentally get something else. So, we've had, especially in the time of COVID, so somebody would go into the hospital maybe for a hip replacement, and then while in the hospital get COVID pneumonia. I mean, the hip replacement was successful. There were no problems. The person recovered from the anesthetic fully, and then they were in hospital and they got COVID. I mean, that's not related to the procedure, So it would really depend on the clinical details, and can you link the events back to that original procedure?
Okay. So, Malinga, measures or process to take if a patient accidentally mentioned as natural death instead of an unnatural on the death notice form. Yeah, I think it's an administrative error, this one.
So in other words, is it saying that that somebody it was called natural and it was actually unnatural? Is it something like that? So was it thought to be?
It looks like that's what they're saying here. Yeah.
Okay, so we do get cases like that. Often what happens is that the families or somebody then reports to the police that, look, this person didn't die of a natural cause. The police would then, based on the evidence of what is presented to them, decide that this case needs to be investigated. And then if the police feel like there's enough evidence to say that something is unnatural, then the police would then open an inquest docket. And once they've done that, then the medico-legal post-mortem can be held. So it depends on the circumstances under which the mistake was made. See,
what happens if the patient is already buried?
They get exhumed. Yeah. So if there's evidence, so if somebody was buried and it states natural causes, but there's strong evidence to suggest that it's not natural causes, then the magistrate can be approached for an exhumation order based on the evidence presented, and the magistrate can then issue this exhumation order for a medico-legal post-mortem examination to take place. And yes, I've done cases like that.
Yeah, we've had cases in the past. Yeah.
There are cases like that, yes. I mean, the one that always that there's I don't know, for some reason we've had a lot of maybe poisoning cases that have gone undetected, and maybe some evidence comes to light later on, and then we exhume the body. Often it's difficult to see, it's difficult to find things once a body has decomposed, but it is possible. So I've had a case where a man was buried. He had hypertension. He was in his 40s. He was signed out as a natural CVA. But for some reason, there was evidence to suggest that it wasn't natural. The body was exhumed, and I did the post-mortem examination approximately 3 months after he was buried, and I was able to identify a cerebral hemorrhage that was not consistent with a CVA. So obviously, a CVA can give you a cerebral hemorrhage, but it's different from a cerebral hemorrhage related to trauma. So he actually had a traumatic cerebral hemorrhage. Okay, so again, the cases are natural. Does it mean he was murdered? Not. It could have been an accident, I don't know, but it does mean that case was unnatural. So it is possible to be able to find things out even once the body is buried. So if there are any prospective criminals on here that think that once a body is buried, there's no evidence, it's not true.
They can be exhumed.
They get exhumed.
Eddie Perry wants to know, any comment on Form B, a cremation form? I'm not familiar with this. Yeah, cremation form.
Form B.
Form B.
Okay, so honestly, I mean, for me,
maybe let me complete the question. Complete the question. Sorry, any comment on Form B, cremation form? Who must complete the form in case of natural or unnatural death? If a DHA form has been filled by one practitioner, can another practitioner complete the B form? Okay.
So generally speaking, I mean, we as forensic pathologists, we fill in the D form, cremation, but basically on there it states the cause of death. And as far as I know, the medical practitioner who does the post-mortem examination in our cases must fill in that D form, right? Unless there's somebody authorized to fill it in on their behalf. I'm not too sure about the B form because that's for natural cases, but I would assume that it would be the practitioner that has filled in the DHA 1663 needs to fill in the B form. But the process with
Yes,
cremation is that even if you filled in the B form or the D form, there is somebody called a referee, and that person reviews all the cases that are going to be cremated to make sure that there's no information that hasn't been filled in, or there's no case that is natural, that has been signed out as natural but is actually unnatural. So there are people that are called referees that review all these cases before the cremation takes place.
Okay. Dr. Malinga wants to know, which is quite common in some cases, steps to take if a patient family refuses post-mortem due to cultural, religious beliefs or any other belief.
Okay.
Can they refuse to do a post-mortem if it's clearly an unnatural death?
Unnatural. Yeah. So again, that's why on every single one of those inquest slides, you'll see that no consent is necessary. Once the case is unnatural, so if you as the medical practitioner has called the case unnatural, the families cannot refuse that post-mortem. It's difficult because obviously, it creates a lot of emotional reactions from the families, but it is your duty. You saw there, it's a legal obligation for you to report an unnatural death, right? If you don't report it, you can be held liable. And once a death is unnatural and the police have declared a death unnatural, the family doesn't need to consent. So it's mandatory. How you manage it, obviously, yeah.
Can the police make the call? I mean, in some cases, where the doctor, the hospital clearly says this is an unnatural death, and the police refuse to.
They refuse. Comply. Yeah. Yes. So remember that nothing can happen with the body of the deceased without a DHA 1663. So if you say death is unnatural, you tick the unnatural box, you don't fill in the rest of the DHA 1663, you report to the police. Then they have to then send the body for post-mortem examination. Otherwise, nobody's going to be able to sign that body out.
So in this case, the doctor has the power of the pen.
In fact, you will see that the Birth and Death Registration Act, and the Health Professions Amendment Act, and the National Health Act, they give a lot of power to the medical practitioner to be almost the deciding factor as to when a case is natural or unnatural when it comes to hospital deaths. So, there's a huge ethical and legal obligation on the medical practitioners to make the right decision based on the information that is available in the laws and the guidelines, because they are actually the gatekeepers of what is natural or unnatural.
Yeah, but in the case where I've seen it in the past, where the family and the police and the medical practitioner would agree to sign an affidavit that the family is refusing to have a post-mortem. Is it legally allowed? I mean,
it's illegal.
I've heard of cases like that.
Look, I'm sure it happens because, I've also heard of cases like that, but it's actually illegal. So, the law is clear. Unnatural death needs a medico-legal post-mortem examination. That's it.
Yeah. And Dr. Wanaka wants to know, must the medical practitioner take fingerprints of the corpse?
No. Generally speaking, there is a place for fingerprints, and if it's a natural death, it's usually the undertakers that can do it. But it's not really, the medical practitioner is not obliged to do it, as far as I'm aware. As long as somebody does it and it's on the form.
Yeah. There's another question sent to me directly. Does the judicial system in South Africa recognize sudden death following COVID-19 vaccination as a vaccination complication? And what is the consequence, if any?
So a natural death from COVID-19 would be a natural death, but if it is vaccine related, so in other words, if death is directly linked to a vaccine, any vaccine is unnatural. So any death that occurs from a vaccination or even a medication for that matter becomes unnatural because it's death due to chemical influence.
Yeah. I suppose the last question that is optional, that it says, what is the consequence, if any? Isn't that a matter for the inquest to determine?
No, I mean, remember that the inquest will determine whether or not somebody is responsible. So just because a death is unnatural, it doesn't mean that necessarily somebody is responsible for that death. So in the case of a vaccine effect, I mean, I don't think if it's a adverse effect that was that occurred and there was no contraindication to giving the vaccine, then I mean nobody would be responsible for that death. It would be unnatural, but there wouldn't be a sort of a prosecution linked to that case.
Yeah. Yeah, there's a question now from Dr. Machaj, which I think is common with many medical practitioners. They want to know, why is the forensic pathology report not given to the medical practitioner who actually requested the postmortem when the pathologist report is done?
So remember that a medical practitioner doesn't request a medico-legal postmortem examination. You inform that there is an unnatural death. It's not you to request, because the medico-legal postmortem examination is mandatory. It's part of the law. The reason why that information is not given to medical practitioners or families or insurances is because that case needs to be investigated, right? So remember that every single unnatural case needs to go through the court system, whether it be inquest court or prosecutorial court. And that information, according to the law, cannot be released to the public until a finding is made. So if it is an inquest case, that finding needs to be made by the inquest magistrate. And if it's a criminal case, the finding needs to be made in a criminal court. So until the case has gone through court, that information remains what we call sub judice, which is under the law. So nobody can have access to it except the SAPS the police investigating officer, and the legal people doing the legal case.
Do you know how long is the waiting period for the inquest at the moment in the country? I mean, like, I'm asking this question because if a patient like this, the doctor is asking, you want to know.
So no, I don't know.
Without knowing what is the cause of death.
Yeah, no, I don't know. But what often we can do is that in an academic setting, we can do what we call morbidity mortality meetings. That is something that you apply for based on the merits of what you're using the information for. We use it for academic purposes. There's no names of it's anonymous. So in other words, the information is not released to the public. It's used purely for looking at processes in the hospital or improving processes in the hospital. Then, that is possible, but we'll never give you the report, for example. I mean, you'll never get access to the report, but you may get relevant clinical information that can help you with the SOPs that you have in place in your hospital. However, it does mean that if there's, for example, these negligence cases where it's an act of commission or omission on the part of the medical staff that has led to a death of a patient, then the medical staff would be directly implicated in that case. So any case related to that kind of thing, information will not be given at all, even in academic setting.
Okay. Maybe just for clarity, if it is known that there's a medical legal process, yes. So you will not give that information even if it is for academic reasons. If Correct. You know, if you happen to know.
That's
but if right. You don't know, yeah.
So it really depends. I mean, it's difficult to then again have a blanket rule for these things. Often it's something that, again, it's got to be individualized. But generally speaking, I mean, if you find that somebody's done a procedure and it's basically disastrous because of what you find, you're not going to share that information because obviously it implicates the medical practitioner directly, and it won't really help the medical practitioner because it would bias the case. So that type of information we wouldn't share. We, like I said, but in academic settings, so it's very specific with confidentiality clauses in place, and with the fact that information cannot be shared, it's possible to get information to help the SOPs or the practice of the clinicians, right? But again, it's got to be done in a very specific way.
Yeah. So maybe just to take this discussion forward, the matter cannot be subpoenaed. I mean, they cannot institute a prior process on the discussions that are taking place in the M&M, even if it is anonymized. Sometimes maybe they might, you never know what people do, what families do. But if it is anonymized and then there's what is called a feedback for academic purposes, that information is privileged information also.
Correct. That is correct.
Okay. Dr. Mlauzi, again, what do I do in a case where I have examined the body and signed it off as natural death, and some of the family members are now adamant that the death was unnatural?
It's based on evidence. So, I mean, if the family members can produce something to you to indicate that the death is unnatural, then you need to listen to them. But if it's just like, I mean, I've had cases where families insist that the death is unnatural because the spirit of the deceased spoke to them or something like that. I mean, that may be a strongly held cultural belief, but it is not evidence, right? So you have to base it on what evidence is available. And the same thing goes with the police. So if the families go to the police and say, listen, this death is unnatural, they've got to produce evidence to indicate why this is unnatural.
But can they request a medical postmortem and pay for it?
So remember, if the families want to have a postmortem after you've signed it out as natural, but they want to have a postmortem, then they would get consent, or they would. I mean, you as the medical practitioner can get consent to organize it, or they can organize it. So they can either get it done through a private pathologist or through something like the NHLS, the families themselves. There's nothing stopping them from doing that.
Yeah.
Yeah.
Yeah, Corey Peters is giving us some advice that the National Injury Mortality Surveillance System assists with tests done by the MRC and UNISA.
Yep.
So that's the information that we can access then.
So in fact, NIMS in South Gauteng, we were doing NIMS. The last NIMS data we have is 2007 because that collaboration stopped. So we're trying to restart it again, but NIMS in South Gauteng finished in 2007. I know that in certain places there is still a collaboration where they do the stats, but not in Gauteng at the moment. Okay. Yeah.
This has been quite an interactive session. I think this is a record attendance that we had tonight. And the discussions show also, we almost hit 400 participants tonight.
But I think it's because that the information that we have is not often widely enough disseminated to medical practitioners. So I think it's very important that medical practitioners do need to know the law. They need to know where they fall in the different laws so that they can protect themselves really, and to make sure that they are following the correct processes. And often that information is just not easily accessible.
Yeah. In case we don't cover all the questions as we're running out of time, there's a request for, I think, two things. The presentation can be made available to all the participants.
Yes.
Yeah, and secondly, people want to know how to contact you.
My email address. I'm sure you have my email address.
We can share that email address.
Yes, you're welcome. And then if it's directly related to any questions within my cluster, which is covering the Diepkloof, so I'm in Diepkloof, so anything around the Soweto area as well as the Sebokeng area, you are welcome to contact me if you have direct questions about it. But also remember that every single forensic pathology service has got doctors that you can consult with. So if you have a question, contact the FPS service in your area, wherever your cases get referred to, and the doctor should be able to answer your questions.
Yeah, because we've got participants from outside the Gauteng province.
Same.
They can find somebody like you wherever they are.
Maybe not exactly like me. but medical practitioners.
I mean, the same position as yourself.
Yes.
Well, quite accessible as you are. Somebody that okay.
Yes.
Yes. No. Thank you. I'm even lost track of the questions.
So they're welcome. Yeah.
Yeah. There's a question. There was a question by Dr. Rangakali earlier on. I think there's this one here from Mishra. Hello, ma'am. A patient was recently admitted with eclampsia and premature labor. Later, I think it was a DNC was done to evacuate the uterus, less than 8 hours, and on CT, throughout her stay, the GCS was less than 8. And on CT, we found it was subarachnoid hemorrhage. Later, her brain stem test showed she's brain dead. Will this be considered in a natural death?
I think the findings were related to the eclampsia, isn't it? So
Yeah.
although you did an evac, I mean, the findings that killed her were the hemorrhages, which is related to eclampsia. So the procedure did not play a role in that death, unless she died during the procedure. But the procedure in that case most likely wouldn't have contributed, I would say, unless there's some factors about the procedure that I'm not aware of. But just from that clinical history, it doesn't seem like it was related to the procedure.
Yeah, Dr. Ranaka wants to be a psychiatrist now. I think he wants to look after the pathologists. Now, he says prevention of pathologist burnout syndrome. Is this done by the employer?
So we have, I can only speak about, in Gauteng, we have a wellness department, and they're supposed to look after our wellness. So we do have something in place to help not only the pathologists, but all the forensic pathology staff do have access to those resources. Thank you very much for asking.
Okay, thanks. I think there's another about it, medical practitioner requesting a PM result as part of an academic team. But I think this should be in an academic setup.
Correct. And you need to obviously follow very stringent confidentiality clauses and the way in which things are done.
Okay. Yeah, there's someone who's given some advice about the National Department of Health having data on the leading cause of death, including manners of death. I think thanks for that information. Sure. I think we've run out of time. I don't know if you've got time for another question.
I can do a last question, it's fine.
Okay, where poisoning is the clear cause of death on postmortem, do you write poisoning or not inconsistent with poisoning pending toxicology results?
We are people that are evidence-based. So if I can give you an example, most of the time we need to find the poison within the stomach contents or the blood. All right, we need to identify the substance. But for example, if you know that it's something like a carbamate and you have a red cell esterase level that can guide you, we can use that because it's an indication of something of a poison. But generally speaking, for you to say that poisoning is a cause of death, we have to identify that toxin or poison, because again, it's based on evidence. So everything we do is based on evidence.
Okay. Yeah, I think let me just maybe last end with this one by Dr. Maling. I wanted to know if there is a site or a page with relevant forensic pathologist contact details to get help and decide whether death is natural or unnatural. Say someone, maybe I suppose I'm not sure if it's at the hospital, but after hours, there is a call list for pathologists.
So we are obliged to have somebody on call 24/7. That's how we operate in South Gauteng. We always have a pathologist on call. We are the pathologist is supposed to answer questions, supposed to attend scenes, supposed to do after-hour post-mortem examinations. So there should be somebody on call in South Gauteng. I'm not sure how the other provinces work, but most of the major provinces, as far as I'm aware, has always got a forensic pathologist or forensic medical practitioner on standby.
Yes, yeah. Sure. There are lots of thank you messages. That's a brilliant talk, quite informative and much appreciated. And I think that's the sentiment I want to express also, that this has been quite a very valuable time that we spent with you. And we just saying that we've not met physically, but we've chatted for a number of years. You've been quite helpful, and it shows also this presentation that you quite helped many of us this evening. They're both administrators, medical practitioners in practice. I've seen a number of nurses, those who work in the hospitals, that you quite help us, and also both in public and the private sector. And I know that we'll get the presentation, but also there's not the last time. You'll get more questions, I think, after this from people who've logged in. as participants. So just warn your team that they will be getting
They're
lots and lots of
phone calls.
calls for
I'll let him know. I'll let him know. Thank you.
Yeah, and also there's a summarized version of the presentation that we put on the notice board just to show the stepwise approach to say natural
that
or
last
natural.
page. Yeah, it's very helpful. Yeah,
It's
you're
very
welcome.
helpful.
Yeah.
Thank you very much, and thanks for accepting my invitation. We'll call you again.
So welcome. Have a good night.
Yeah.
Good night, everybody.
Yeah, just want to thank all colleagues who've logged in this evening. Thank you very much for participating. It's been quite an informative session, and we appreciate your attendance, and we hope to see you again next week. And thanks to Clinics Health Group for availing this opportunity for us to be presenting this webinars from different experts. And thanks to Kamu behind the scenes, who's doing logistics and marketing and contact logistics for this. And have a good night. Good evening.